Good morning and welcome everyone to this session of the Committee on the Revision of the Penal Code, which is now in session. I am Mike Romano, Committee Chair, and your host for this morning. We'll begin as always with a roll call of committee members in alphabetical order. Assemblymember Bryan, he's not come here yet, but he's on his way. Judge Espinoza is also on his way. Professor Ochin,
Here.
Professor Rummel,
Here.
and I am here. That makes a quorum. I also want to just give a quick shout out to our staff attorneys, Tom, Rick, and Joy, who are here with us and who truly make everything this committee work. And so they'll be joining us as well. And thank you all for joining us. So it's been a while since we last convened, and it's good to see everyone. As usual, we have another packed agenda, but we hope to move quickly, and our plan is to wrap up shortly after lunch break. Our main topic today is criminal defendants who are survivors of intimate partner violence. We'll begin with two data presentations, then turn to two panel discussions, and we'll have a final presentation before lunch. After lunch, we'll hear from staff and discuss the ideas presented earlier in the day, and we'll conclude, as always, with public comment. Just a quick reminder about Bagley-Keene. As required by law, members of the public can watch and participate in this meeting in person at the Gregory Conference Room at 925 L Street in Sacramento. Thank you, Megan, for being present at that location for us. And as a reminder to committee members, the law requires that members be visibly on camera during the meeting unless there are technical difficulties. Cool? All right. I also wanted to say a quick welcome to Senator Wiener, who is not here. But before we turn to our business, I just wanted to say how thrilled I am that he's joined our committee. And although he can't join us today, we're really excited to have him aboard. He's been a leader on these issues for many years, and we look forward to working with him. Okay. Turning now to our main topic of today's meeting, how California's criminal justice system treats survivors of intimate partner violence, which we'll be calling IPV today. Our focus is on criminalized survivors. That means people, predominantly women, who are prosecuted for offenses directly linked to their experiences of abuse. This can include defending themselves against an abuser, being coerced into committing crimes, or failing to protect their children from harm. While the legislature and governor have taken significant steps on improving our system, when it considers the effects of IPV, there is still a lot of work to be done. And as we'll explore today, some legal standards at play in these cases have not been updated since the 1880s, literally, or the 1800s. Finally, because so many of the issues we'll be exploring today apply with special force to women in prison, I want to acknowledge the disturbing reports of sexual abuse by correctional staff at California's 2 prisons for women. These reports led to the U.S. Department of Justice to launch an investigation last year into these problems, and I know that the legislature and governor are giving it a high priority this year. These reports are unacceptable to us, and I hope quick action is taken to address them. All right. With that said, let's begin. Assemblymember Bryan has just joined us, so let the record reflect that he's here. Good to see you, Assemblymember. Thanks for joining. Excuse me. All right. Our first presentation today is from Alyssa Skog from the California Policy Lab, which is our research partner based at UCLA and UC Berkeley. Her presentation about trends in arrest and incarceration for women in California will give important context for today's discussion. She'll present for about 5 minutes, and then we'll have some Q&A. Alyssa, please take it away.
Great. Thank you. Good morning, everyone. Let me just make sure screen sharing is working. Y'all can see it. Great. Thank you so much. As Michael said, I'm going to be presenting some very high-level descriptive statistics from a forthcoming brief we'll be releasing about women in prison in California. So as you all know, women make up about 50% of our population, yet they comprise a much smaller share at all points of contact with the criminal justice system, as you can see in this graph. In California, arrest trends have been declining since 2010 for both men and women, and they declined sharply during the COVID-19 pandemic. And since 2010, we've seen arrests for women decline by 44% and arrests for men by 43%. And then when we look at jail populations, we did see an increase in the wake of realignment for both men and women, as you can see kind of around the 2010 mark. And then following Prop 47, we saw jail populations go back down to their near pre-realignment levels. And then similar to arrests, fell during the pandemic. And when we look at kind of the overall change in this kind of 20 plus year period, there's a 17% decrease in the jail population for women and 11% for men. And in California, today, the prison incarceration rate is close to a 20-year low for both men and women. For women, we've seen the prison rate decline by nearly 70% since 2004, which is greater than the 43% decline we've seen for men. And women account for about 4% of the prison population in California today, which is smaller than the national average of 7%. So women who are admitted to CDCR have shorter sentences on average than men. So the average sentence for men admitted between 2014 and 2024 years was about 2 years longer than the average sentence for women. So 6.6 years compared to 4.2 years for women. And nearly twice the number of men than women admitted during that period had a sentence that was 10 years or longer. And this difference is even greater when you look at the currently incarcerated. So among that population, the average sentence for men is about 30 years compared to 14 years for women. And this shows us the difference of sentence type by sex. So these two graphs are ordered by severity of sentence. So you have condemned at the top, LWOP, and then at the bottom is determinate sentences that are 10 years or less. The left-hand side shows us the distribution across sex for admissions, and the right-hand side shows us the distribution for currently incarcerated. And so what you see here is that in both groups, but particularly in the currently incarcerated, a greater share of women have a sentence that is a determinate sentence of less than 10 years. This table shows us the most common offenses that women are admitted to prison for. Oops, sorry, an antivirus pop-up. So women, the three most common controlling offenses for women admitted are assault, burglary, and robbery. And for men, it's assault, weapons charges, and robbery. And what this kind of shows us is even within the same controlling offense category, we do see differences in sentence length. So among women who are admitted with an assault offense, the average sentence length is 3.9 years. For men, it's about 5.8 years. And one of the explanations of this difference in sentence length is enhancements. So fewer women are admitted to prison with enhancements. When we look at the 10-year admissions window from 2014 to 2024, 42% were admitted with enhancements compared to 32% of women. And then amongst those who are admitted with enhancements on average add nearly double the number of years to men's sentences than they do to women's sentences. So men with enhancements get about 5.6 years added as a result of those enhancements compared to 3.1 years for women. And then that difference is even greater when we look at the currently incarcerated population. So amongst men currently incarcerated, on average, enhancements add about 20.6 years compared to 8.8 years for women. And another explanation for these differences in sentence length is likely differences in criminal history. So among women admitted to CDCR, for 65% of them, that admission was their first to CDCR compared to 45% of men. And then when we look at demographics of women who are admitted to prison, we see that a greater share of women admitted were white compared to men. So 35% of admitted women were white compared to 24% of men. And we also see differences in American Indian, Alaskan Native across men admitted and women. And lastly, a greater share of women admitted were in that age group of 26 to 40 rather at the point of admission. So almost 55% of women admitted were 26 to 40 compared to just under 50% of men. So in conclusion, some very high level stats to share with you today, but there are about 3,600 women incarcerated in California's prisons today, which is about 4% of the state's prison population, less than the national average of 7%. And as we showed you, women on average have shorter sentences than men, which is explained in part because of sentence enhancements and fewer prior admissions to CDCR. Thank you so much.
Wow, that was super helpful. Thank you so much. Heidi.
The super lot of information. I was wondering if you had the breakdown, the age groups, the under 26, 26 to 40, by whether they were violent crimes or non-violent crimes. I'd be really interested in that number.
We do not, but that's something that we can definitely do.
I had a question that applies, I think, to,
Can
oh,
I
sorry.
ask my question real quick? Sorry.
Oh, sorry. Yes, of course. Go ahead.
So I appreciate thank you so much, Alyssa, for the presentation. I find that when looking at women's populations, particularly when it comes to custodial populations, that it's very interesting, of course, to compare men with women, but I often find that it's particularly interesting to look at distinctions among women to get a sense of trends. So, if we're able to understand the racial breakdown among women, I think that would be really interesting to see where, Black women as compared to Latina women or white women or Indigenous women, kind of what that looks like among the categories that you described. I'd be interested in the geographic distribution. Where are most women coming from? And the other is comparisons with other states. So, for example, I know that there have been studies, I think maybe by the Sentencing Project and elsewhere, that have found that California has one of the highest rates of women serving life without the possibility of parole. And given the nature of our discussion today, I'd be interested in knowing whether that's true still, because I think that study was from some years ago.
Thank you. That's all very helpful feedback, and we can definitely incorporate that.
Thank you.
Assemblymember Bryan, you're mute.
Only because I had my hand up before I heard what she was going to say, which is very similar to what I was thinking, that perhaps looking at outcomes amongst women might draw an interesting set of conclusions or trends. Especially, I think the only disparity that I think seemed to be different between men and women is that Black women made up a greater share of all women than Black men make up of all men, based on the slides that, not much, based on the slides that you just showed, but I think that might be interesting.
Thank you.
And my question was going to be, it seemed to me that you did your best to compare sentences for men against sentences for women, and particularly in assault. And we obviously understand that that's like kind of a wide variety of conduct. And by using enhancements, we sort of inferred that women who basically commit the similar conduct, seems to me you're suggesting, get shorter sentences for the same conduct. But is there any better way that we can, I mean, in general, as we look at this data, compare conduct to conduct, especially when they're wide crimes like assault or robbery, or is just we have to kind of look at the enhancements? And do you have thoughts on that?
Yeah, I think that's a great question. And I do think that that's one of the things we want to go a little deeper in, because there's a few things, right? So you, exactly as you said, you can imagine differences in the number of charges, because we're just looking at that big broad category of assault. You can look at differences within the statutes for which someone is convicted of, and then getting more detail into what are the actual enhancements and maybe the numbers of enhancements. So I think that that's your question, that we can kind of provide more granularity about what is maybe explaining those differences. Is that a correct understanding of your ask?
Yes, I mean, it applies to this data in particular, but also as we get into other data, is how do we compare robberies from Los Angeles to robberies from Alameda when it's such a big category,
Yes.
acknowledging that they're all plea agreements and that we really want to compare conduct to conduct. And is there any way to do that in a rigorous way? It seems
Yeah.
like the best we have right now is the enhancement piece, which gives us further, but
Yeah, and it's always the conduct convicted of, because that's what
right.
we can observe, obviously, in the data. So, but yes, that's great feedback, and definitely something that we'll take back.
All right. Super duper helpful. Excellent presentation. Any other questions from committee or staff?
I had one quick one. You talked about this a little bit, Alyssa, but sort of the impact of realignment. Because I think our prison population or rate is lower, and part of that is because folks who would have been in prison are in jail. Did you see any differences in sort of the impact of realignment on men versus women?
Yeah, great question. So definitely, as we said, it affected both groups, but there was a greater decrease for women. So kind of if you look 2 years prior to realignment and then 2 years post, women's admissions dropped by 60%, men's dropped by 31%. Kind of similarly, we saw a bigger drop for women relative to men in the COVID period as well. And then interestingly, the like kind of post-COVID, the men's prison rate kind of rebounded closer to its original than women. So you did kind of see both realignment and then COVID having a greater shift, a decrease in the admissions for women relative to men.
And I just wanted to make sure I understand something before we move on. It seems like in general, what I was referring to about assault convictions and whatnot, that the punishments seem to be lesser for women. But what Professor Ochin was referring to is an older study that said that maybe women have a disproportionate number of LWOP sentences. Is that just your intuition? Are you looking into it, or do you know it? I mean, that would seem that's just surprising a little bit. Professor Ochin, is that basically what am I summarizing your?
No. I
Okay,
was saying
all right.
that California, of all women that have been sentenced to LWOP across the country, California has a disproportionate share among women, not among all people with LWOP in the state of California.
I see. And do we know women, not just LWOP, do we know the population trends for women nationally across other crimes too?
Yeah, that's what I mean. I think it's less helpful to look at women in comparison to men because, of course, like women are going to be dwarfed in all categories in comparison to men. But I think what is helpful is to compare women's populations to other women's populations to get a sense of trends.
And Alyssa, correct me if I'm wrong, I think that you said that California was generally below the national average, but that was just an overall incarceration rate. And
Correct.
that alignments kind of skews that. And so maybe we don't.
Yes.
All right.
Yep. Overall, yeah. What Professor Oaken says can be true as also with the overall being lower. So it's important, I think, as she raises to look at both those. So it's great feedback.
All right.
If
Cool.
that's a number you can get quickly, the LWOP disparity among women in California versus women in other states, I'd love to have you like send that to the committee or make that available to us instead of just including it in your report. That'd be
Okay.
super helpful. Thank you.
Yes.
All right. Like I said, really excellent presentation. Any other questions among committee or staff? Alyssa, thank you so much. Have a good one.
Everyone.
All right.
Wait, I'm so sorry. I do have one question.
Okay,
before
go
you
ahead.
log off. So I know you mentioned realignment, right? So that means that more women are in local jails, and obviously you mentioned that the jail populations have decreased as well. But I'm wondering if there's any data that would be relevant to kind of what happened, what's from the jail populations that might be useful for us to help us to understand kind of the issues that we're talking about, intimate partner violence. Um, if you're able to access that information. So are assaults going up, arrests for assaults, for example, going up for women? Those are the kinds of at the local and in our sentences, what's happening with sentences for those kinds of offenses where we might understand intimate partner violence to be playing a role. That would be helpful from the local level so that we can get a complete picture.
Yes, and we can definitely do that for arrest and sentencing trends. We don't really have granular data on jail incarceration, but we can absolutely, as you were saying, about kind of arrest and sentence trends for women in those offenses.
And
Thank
Tom,
you.
correct me if I'm wrong, we will eventually be getting that jail data, correct?
No, I don't think that exists.
Okay,
Unfortunately.
never mind. All right. Any last questions? Yes, Assemblymember Brian.
Yeah, not necessarily in regards to this work. Just want to thank you again, Alyssa, for bringing this forward. Something for us to potentially think about as we look in this direction might be conditions of confinement for women who are incarcerated. Is solitary used more on any particular type of women or any facilities using solitary more than other facilities, or just kind of and I know that's not easy data to get your hands on. It should be easier for the state to get its hands on that data. But just something for further inquiry in a different lane, but on the same topic.
And that just reminds me that I'd also be interested in mental health data if there are disparities there. No good deed goes unpunished, Alyssa.
Awesome. This is great. This is really helpful feedback. Thank you all.
All right, thank you. Like I said, have a good weekend.
You.
Speak now, forever hold your peace. All right, we're gonna be moving on. Thank you all. So our next presenters are my good friend Debbie Muckamel and Andrea Semino. I hope I pronounced that correctly. From the Stanford Criminal Justice Center. They are presenting on elements of their recent groundbreaking report called Fatal Peril, which is key data about the prevalence of IPV experiences for women in prison. They'll present for about 8 minutes and then we'll have Q&A after that. Debbie and Andrea, it's great to see you. Take it away.
Got it. 1 second. Good morning. According to the Centers for Disease Control and Prevention, 24 people are abused by an intimate partner every minute in the United States. Some will be killed by that partner, and some will be arrested, convicted, and sentenced for actions like homicide that arose out of their own victimization. In many of these cases of survival, the law fails to account for intimate partner violence, or IPV. Good morning. First, we want to thank the committee for considering how California's criminal legal system can better account for defendants' experiences of IPV. Today, we'll be discussing findings from a study we published in September titled Fatal Peril: Untold Stories from the IPV to Prison Pipeline. Despite research suggesting that IPV accounts for 15% of all violent crimes, little is known about abused women's experiences as homicide defendants. Our study sought to understand the abuse-related pathways that led to murder and manslaughter convictions among people incarcerated at 2 women's prisons in California. We administered an anonymous self-report survey in person in July and November 2023 and collected responses from 649 people, which is over 58% of the target population. We used validated scales to assess intimate partner violence and intimate partner homicide risk, the first time these measures were used with an incarcerated population. We also asked about the respondents' relationship to the person killed or the decedent and the circumstances of the killing. Briefly, we found that a high proportion of our sample experienced intimate partner violence the year before the killing, most of whom were at extreme risk for intimate partner homicide, and that lethality from abuse extends beyond the person experiencing violence to their children, strangers, and other bystanders. Dr. Semino will now present our key findings.
Thank you. Our study's first aim was to determine how many people experienced IPV in the year before the killing. To do this, we administered a modified version of the composite abuse scale. This includes questions such as, did your partner hit you with a fist or object? Did they track you? Did they confine you in a room? And so forth. Results showed that 74% were abused by an intimate partner the year before the killing. Abused women then took the danger assessment. This measure is used extensively by domestic violence shelters and law enforcement to estimate the risk of being killed by an intimate partner. It includes indicators of lethality like, did your partner threaten to kill you? Did they own a gun? Did they control all or most of your daily activities and similar items? Our results showed that 2/3 of abused respondents were at extreme risk of being killed by their partner the year before the killing. And contrary to what we hypothesized, homicide risk was not higher among those who killed a partner. There were no statistically significant differences in lethality by decedent type. So in other words, it didn't really matter who was killed, a partner, a family member, a stranger, or a child. Most of the respondents were experiencing potentially lethal abuse the year before the killing. When we looked at the 464 women who experienced abuse, 24% were found responsible for killing an intimate partner. Some of these killings were done in defense of self or others, such as their children, some also by accident. Common among them, though, was this sense of fatal peril, a persistent belief that their life was in danger, often from an accumulation of their partner's threats and attempts to kill the respondent, her children, or her family member. These happened over time. This belief was exacerbated by their inability to leave the relationship. Nearly half of respondents attempted to leave their partner the year before the offense. This is a predictor of lethality that is well documented by the domestic violence field. Few were able to obtain assistance from law enforcement, and close to half said their partners avoided arrest the year before the killing. The handful who were able to leave said that they were stalked, tracked, or kidnapped and brought back to their abusive partners. Others had too few resources or feared that their partner would challenge custody of their children if they left. Respondents were found responsible for killing more than just their intimate partner. Indeed, those who were abused, 26% were convicted for killing a stranger and 16% for killing a child. These non-partner killings revealed the collateral effects of severe and chronic abuse. These were killings that included vehicular homicides stemming from abuse that led to the death of a stranger, coercive control killings where respondents felt forced to participate in robberies, carjackings, and other crimes that led to the death of a stranger. And among child decedents, this included women convicted under failure to protect liability, in which they were held responsible for a killing committed by their partner, sometimes while the respondent was at work, in another room, or unconscious from being strangled. In other words, this near lethal IPV creates these dangerous circumstances that can increase homicide risk for everyone around those using and experiencing violence.
In our examination of the types of violence respondents experienced, we were surprised by the frequency of strangulation. About 60% of respondents were ever strangled or choked, and 78% of those, 218 individuals, reported being choked multiple times or until they were dizzy, passed out, or blacked out, which are all symptoms of a traumatic brain injury. A TBI is an injury that causes an alteration in brain function. It can lead to problems speaking and understanding information, memory loss, personality changes like impulsivity, depression, and anxiety, and chronic pain that make it hard to function. Given these effects, having a TBI while navigating the criminal legal system, a system that prioritizes accurate and consistent ability to remember details, can be especially challenging for an IPV survivor accused and convicted of murder and manslaughter. Strangulation isn't the only way to get a TBI, though. Punches to the face, head or neck, being shook or slammed against a wall, or pushed downstairs can result in a TBI, which many of our respondents also experienced. Physical injuries often lead survivors to seek health care, where they can get connected to domestic violence services. However, only 25% of our respondents saw a doctor for an injury, while 50% said they needed to see one but didn't go. To summarize, findings from our study suggest that potentially lethal IPV is common among women incarcerated for homicide. There are collateral effects of this violence, and that many abused women may have suffered TBIs. Our report includes additional findings than what we have shared today. As we conclude, we want to emphasize that it is imperative that we listen to IPV survivors. Their stories are very complex, and they have a lot to tell us about how IPV manifests and how it should be accounted for by the criminal legal systems. We're pleased to answer any questions you might have.
Thank you. That was super helpful and informative. And for those who have not read the full report, I really recommend going to find it. Professor Ochin.
Thank you so much, Debbie and Andrew, for your presentations. I'm wondering if you can talk a bit about your findings when it comes to, so you mentioned a couple of different legal theories that might exacerbate that do exacerbate the violence that your respondents had experienced. So the failure to take into account the effect of IPV on the conduct that's being criminalized, for example. You mentioned accomplice liability and failure to protect. I'm wondering if there are other areas that you found were particularly prominent in terms of the legal system's response to a criminalized survivor of intimate partner violence.
Andrea, did you want to take that or you want me to?
Go ahead. I'll follow up.
Okay. So first, I just want to say that we're limited. Our respondents provided narratives that were somewhat open-ended in what we asked them about, right? So we asked them about like the nature, if they had a case that involved self-defense, like we wanted them to share their story. And so some talked about different parts of it. We couldn't verify anything, like we couldn't go back to their case records. We didn't talk to defense attorneys or prosecutors or anything else. So it's really limited to what they shared. And some shared about the abuse, some shared about the nature of their criminal case, and some shared just about what it's been like for them to be in prison, like with these kinds of having this kind of experience in their background. I would say that among those, for instance, who killed an intimate partner, it was clear that the current self-defense statute didn't really work well for them. It is difficult. The imminence requirement makes it difficult, and it does not account for what Andrea spoke about, which is like this fatal peril, this accumulation of threats. When you know that every time your partner goes drinking with his buddies and he comes home, that he's going to bash your head in, like on the 8th time that happens, you may be prepared and you may have a weapon. Getting back to the previous presentation that you just had, you may have a weapon because there's a physical difference in size between you and your intimate partner. And so it's interesting around enhancements, because enhancements really, I think, plague this population, particularly when it comes to murder and manslaughter convictions. And that's something that maybe fine-tuning the data that you get around enhancements for these kinds of convictions might be useful. In terms of failure to protect and accomplice liability, those definitely like were things that arose in our population, being coercive control. I know you're going to have a panel on that later. And then finally, I want to say there was a particular, like, we had at least 16 women who talked about the fact that the abuse was so bad, they self-medicated with drugs and alcohol, and then they got into a DUI and killed a stranger. And those are probably not cases when we look at a DUI that we're thinking about a connection to IPV, but we need to be thinking about that because they're self-medicating because the abuse is so bad. Andrea, I don't know if you want to add anything.
The only thing I want to add is that it seemed to be particularly difficult for this population, the population that fights back, if you will.
In progress.
Have evidence. So Debbie had mentioned about 25% saw a doctor and documented the injuries that they had. I think in other domestic violence samples, it's closer to 30, not quite 30. So I think it's just really difficult for these women to access services that we traditionally use for domestic violence and use for evidence in their defense. And part of that is because they were in such highly coercive, controlling relationships. And related to that, I think something that the current criminal legal system neglects is how dangerous it can be for a victim of violence to seek help. That actually puts them at more risk. And some of the respondents who did seek help talked about how they couldn't get it. Their partner pulled the phone out of the wall or, threatened to kill them if they ever did call the police or sought legal help again. Over.
This is all super helpful. A couple of things. First of all, I want to acknowledge that Senator Weiner has joined us. Senator, good to see you. And welcome to our committee. This is his first appearance here on the Committee on Revision of the Penal Code. Thank you so much for joining us. You've joined us mid-conversation about a report out of Stanford called Fatal Peril about the effects it's a study of women who are in prison for homicide who experienced IPV some point in the year, basically in the year prior to their conviction or crime. So Debbie and Andrea, I had a question, which was, does your report, and forgive me if the full report includes this, describe trends along race, geography, or time, meaning has the court system and the legal system sort of caught up to this or the opposite? Do, do you understand my question? And
Yeah, I understand your question. I mean, we have a portrait of who among our respondents who what the race was of the people who responded to the survey. So we can provide that. It matches pretty much what the population is of people who are inside, of women who are inside CDCR. So it does not. We did not ask for the county of commitment, which is something that we wish we would have done, and we're now working in Illinois, and all the things that we wish we would have done, we're doing in Illinois. So and then around time, it doesn't. All it is, the only thing I can tell you about time is like when people were convicted, and so like people were convicted for as long as like 45 years ago, and as recently as like the year before we did the
Right.
survey. So
I'm guessing about the
doesn't.
time question. I'm wondering, is it less of a problem in more recent cases, meaning has the system sort of absorbed some of this versus older cases, or does it not really seem to have been a change over time?
It's a little hard to answer that question because we were just surveying people currently incarcerated. So there could have been people who cycled out that we don't have data on. So we couldn't quite answer like you're asking.
We also, yeah, just to add on to that, Andrea, is that we also don't know who was not convicted. Right? We
Right.
don't know who was maybe charged and not convicted, or who wasn't charged at all, right? We don't have that data.
And then I'll say that we examined all of the demographics, so including race and ethnicity differences in experiencing violence, so that composite abuse scale and the lethality, and there were no differences by race or really any of the demographic characteristics in terms of whether they were abused or how lethal the violence they were experiencing over.
Debbie or Andrea, it seems like you've read our memo and recommendations, the staff recommendations and memo. I was wondering if anything stood out in particular to you, either of you, as particularly useful in addressing the concerns that you guys have raised.
Yeah,
Or
I mean,
anything else that we should consider. Maybe I should also say that.
yeah, I mean, I thought it was excellent. We were particularly like pleased to see that this fatal peril, trying to address or get at this issue of fatal peril, which is so, I think, really maps out on how IPV actually manifests in real life, as opposed to like where the law is. And I think there's a mismatch right now. And so trying to get like a closer alignment is seen in the memo in terms of the fatal peril, in terms of coercive control, like how many women, right, had to participate in a crime because of the abuse that they were enduring. And then, of course, the failure to protect cases are really emotionally, I think, like very charging for people. And of course, there's the recent Supreme Court case in California, like makes moving in that direction like very, very important. I would say that we brought up the TBI stuff, even though it doesn't match on to like the memo. Just because, and we don't necessarily have like strong recommendations on how to address it, other than there needs to be a lot more awareness among every single actor in the criminal legal system, from policing through to the parole board, on the fact that so many women likely are experiencing traumatic brain injury and the effects of traumatic brain injury, and that really, really, really influences how they move through the criminal legal system and how they are experiencing confinement right now.
Professor Ochin?
I just had a question about that for the staff. Are there areas of our criminal legal system where TBI is taken into account? So is it like, I know we don't have diminished capacity, but like, the insanity defense, or as we think about like, manslaughter versus second degree murder, is TBI taken into account or voluntary manslaughter versus second degree murder? Basically, my question is, are there specific areas where TBI can be introduced as a mitigating factor that would reduce a defendant's culpability for, what would otherwise be second degree murder or an intentional homicide, or for something that's a non-homicide offense? Can TBI be introduced to diminish culpability, or is it considered at sentencing, for example? So I'm just wondering if you all are familiar, Rick or Tom, or Joy, about how TBI is utilized in our criminal legal system when it comes to culpability.
Rick, what do you
the first
think?
stab at
Yeah.
it, which is to say, I think you already kind of identified the big issue, which is the problem that it could be considered a diminished capacity defense, which is not available. And so it doesn't have to our knowledge, have the ability to reduce anything from a second to a manslaughter or anything like that, to reduce the level of a crime that a person is responsible for. I think it can be used at sentencing for mitigation. There's no specific code section that says TBI gets you a lower sentence, but I think a defense counsel could bring that up to a judge or to a district attorney and have, argue that they should consider that, maybe even consider it in reducing a case from a felony to a misdemeanor under Penal Code Section 17B, if that is available. But there's nothing in the penal code that requires or directs or, judges or prosecutors to consider that. The other thing that we thought about with TBI evidence would be that potentially if a witness was testifying that had TBI, that perhaps there could be some expert testimony on the impacts of TBI, particularly as Debbie mentioned, kind of the ability to recall facts, that, you could have a court maybe instruct a jury on that, or have a court consider that. Again, there's no, we'd have to do more research on if there's case law about that. There's no jury instruction currently or penal code section that tracks directly with what you're thinking.
Yeah, and I guess I'm interested in maybe this being a subject. I know you all have done a lot of work on mapping out our agenda for the year, but I'd be interested, I don't know about other members, but I'd be interested in exploring more about how things like adverse childhood experiences and TBI are treated in our criminal legal system, and whether they're adequately understood or accounted for when it comes to charging or sentencing, or at the end of the, sort of the end of the line in terms of parole hearings, because I think these are such major, this is such important information about an individual or group of people, that shapes, how they perceive and interact with the world. And this is for us, for the system not to be well versed or to take it into account, I think, is cruel. Yeah, this is something I think that I hope that we can take a closer look at.
I see your hand, Heidi. Before we get to you, real quick, one question I want to clarify, Rick. So my understanding is that at least some portions of the penal code, like 1385, do include IPV as a potential mitigating circumstance. They just don't single out traumatic brain injury. Is that correct?
Right.
Professor Rummel.
That's part of my point, which is we have places where we ask the courts to consider history of trauma, history of abuse, IPV in the parole context and in the resentencing context. But what I love about this report, and I love this report, and I know I'm a little biased. I was fortunate to be involved in it, but it provides the nuance and the context about why the people you're looking at struggle in all of these processes, struggle to relate their stories, struggle to fit their narrative into the narrow sort of male-centered definitions of self-defense and other mitigating circumstances. And I would suggest, and I love the report, did I mention that? I would suggest that one recommendation for the committee could be to add that nuance to these other places in the statutes. Like, every time we go in and ask the court to be considering IPV or a history of trauma or abuse, that we explain what the court should be thinking about, because the courts don't know. They're like, oh, they don't understand how it impacts all of the experiences throughout the process. And I would also, and this is a small ask, but I would ask you to make a presentation like this to the board at one of their quarterly trainings. I think they would welcome it, and I'm happy to help you set it up. And I think it's really important for the parole commissioners to understand when they're evaluating people who have some of the memory issues and TBIs and other things you've been discussing. Thank you. Thank you for the work on this.
Yeah, can I just add on to that, Heidi, is to say that in a previous report that we did looking at parole board hearings, we found that a lot of the parole board commissioners really had very little understanding of how IPV actually manifests, given like the kind of nuance that you've just discussed. And when we presented that report to the board, many of the board members got very defensive with us, and so I want to keep reiterating that with all of this, the law can be spelled out like very clearly and very like beautifully, but like if we don't also do the training on these decision makers that really relates to how this abuse plays out for people, I think we'll be missing an opportunity. Because people don't fall into these like perfect victim categories that we would like to see. They often don't have the kind of evidence that the law often requires, right? Going to the police, going to the hospital, all those things. And yet, it's true and valid.
And I think one of the struggles is the statistics we saw at the last presentation that, women who are traditionally the people we're talking about, not always, are such a small percentage of our criminal system. It's such a male-constructed, male-centered system. So there's not a lot of time and attention put on their experiences and why they don't fit in some of the regular parameters. And I just, again, applaud your work on this and encourage you to get it out there in every way that you possibly can.
Thank you.
Agree wholeheartedly. Are there other questions from committee or staff? All right, Andrea, Debbie, thank you guys both so much. It's good to see you in this context. See you soon. I'd like to take a 3-minute break. Oh, Judge Espinoza, how are you? You there? Anyhow. Hi, Judge Espinoza. Let the record reflect that Judge Espinoza has joined the committee, the Zoom, just in time for a 3-minute break, and then we'll start our panels. So we'll start back up at 10:25. Thank you all.